Hi, everyone. We'll give Zoom just a minute here to let everybody file in and get set up. Thank you for joining us. So welcome to everybody. It's really great to see such a good turnout for the conversation today. Thank you for joining us, for taking some time out of your Friday, whether it's morning or afternoon or evening, for some to join us for this conversation on constitutionalizing economic, social, and cultural rights. I'm Amanda Lyons. I'm the executive director of the Human Rights Center at the University of Minnesota Law School. And we're co-sponsoring this event together with the program on human rights and the global economy at the Northeastern University School of Law under the leadership of Professor Martha Davis, who you'll hear from in just a moment, and also with the team at the Office of the UN High Commissioner for Human Rights. This is the second time that our programs have come together to host one of the sessions for the UN's annual Hernan Santa Cruz Dialogue Series. And this is a series that the Office of the High Commissioner for Human Rights launched back in 2020 with the aim of creating a new platform and initiative for exchanging progressive ideas and experiences and practices on economic and social rights. So it was in that spirit that we asked our panelists to join us today to share their expertise and insights. And I think Zoom and remote work has really made it feel almost commonplace, but it's really such a privilege to have a great group of experts all together in one space and to set aside some time to hear from them, to get updates and analysis on these different contexts and vantage points. So many thanks to our panelists and for everyone in the audience for making that time. So Martha will be introducing our panelists and moderating the first part of our conversation, but I wanted to emphasize, maybe for anyone new that's joining us, Martha is herself, of course, a leading scholar and advocate on constitutional law and human rights. Martha is the University Distinguished Professor of Law at Northeastern, and there she teaches constitutional law and U.S. human rights advocacy, among other courses, and she co-directs the Program on Human Rights and Global Economy and the New Law Lab. So I encourage you all to follow her work and writing as well in this area. And before handing it over to Martha, I want to introduce Chicholeka Massey from the Office of the High Commissioner. Chitra is the Chief of Partnerships and Constituency Building on Economic, Social, and Development issues, and she's really been a great partner for academic institutions, so it's great to welcome you, Chitra. Thanks for joining us, and I'll turn it over to you.
Good morning, good afternoon, and good evening, everybody. It's a real pleasure to be here, and I'm absolutely delighted about this particular webinar in person. But at the outset, I really want to begin with a heartfelt thank you to both Martha and Amanda and their institutions that have been such amazing partners over the last couple of years. And I'm very delighted that we have an amazing panel of speakers. This is going to be so interesting. And if I can just have your indulgence and talk for 2 or 3 minutes. Amanda has already spoken about the Hernan Santa Cruz dialogues. I just want to add that, in the year that we are celebrating the 75th anniversary of the Universal Declaration of Human Rights, I find it very relevant today that, it's that we talk about 2 things, that the UDHR did have diverse voices and had a universal input from people. And Hernan Santa Cruz is someone who was a Chilean diplomat and who contributed extensively to the integration and inclusion of economic, social, cultural rights within the Universal Declaration of Human Rights. So moving forward, while we wanted to start with this as a tribute, but also as a reminder to people that there is still unfinished business, and that we need to have a greater emphasis on economic, social, cultural rights. Today, given the context, I'm also reminded of the fact that while it is a very visionary document, it still is incomplete, unfinished business. but it is still amazing because it is 75 years later. It is still so relevant to us. And I just wanted to emphasize some of the things that it speaks out to: moderation, tolerance, respect for the dignity of all people all over the world. And as we start this webinar from our side, I wanted to share two phrases that I had the amazing experience of hearing while in conversation with two very amazing women. One was Jayati Ghosh, and she made a very passionate argument about how economics are the creation of human beings and are supposed to serve human beings, and the vehicle for serving human beings and human needs and the planet together through the integration of human rights. And then there was the independent expert on international debt, Atia Varis, who said, well, rights need resources. And these are the two phrases that come to mind when we start this evening, because we have this strong need to move away from human rights free zones in our economies to moving to integrated human rights, economic, social, cultural rights, more and more being enjoyed effectively by people all over the world if we want to ensure a life of dignity. So on that count, I just want to say that I'm very delighted at the topic. I'm really looking forward to hearing all the speakers, and I want to thank all the participants who've joined us today. Thank you very much. Over to you, Amanda. I'm sorry, to Martha.
Actually, to me, yeah. Thank you, Chitra, for that important background for this conversation, and then also to Amanda for that very generous introduction. So just to quickly set the stage for today's dialogue, as many of the folks on Zoom will know, there have been longstanding debates and discussions about the justiciability of economic, social, and cultural rights. And along with that, questions about whether economic, social, and cultural rights have a rightful place in national constitutions. Over the past 25 years, courts, and particularly courts in South Africa, but also elsewhere, have really shown that adjudication of ESC rights is well within judicial competence. Given that, the question of whether such rights are constitutionally guaranteed and the processes by which ESC rights are embedded in national constitutions and then actually implemented at the national level takes on additional significance, since they may actually be enforced by courts. So today we're going to hear from three exceptional experts on this issue of constitutionalization with different areas of substantive expertise and differing roles as scholars, advocates, and even constitutional drafters, but all with deep insights into the evolving status and application of ESC rights. So I'll briefly introduce our speakers now, and then we'll proceed in the order of the introductions. And I'm sorry to report that Denise Cordoba-Montes was not able to join us at the last minute. I'm sure she's here with us in spirit, but it means that we'll have a little bit more time than we thought for dialogue between the speakers and for questions at the end of their presentations. So if I told you all of their accomplishments, we wouldn't have time for any dialogue. So, for more information, someone I think who works with Amanda is going to put in the chat or make available full bios, and I'm going to just give headlines in terms of introductions for each of the speakers. So first we'll hear from Professor Domingo Levera Parmo, who's an associate professor at the Universidad Diego Portales in Chile. Professor Levera Parmo's scholarship focuses on public law and human rights, including social movements. He holds a unique position as a member of the expert commission that is currently in the process of attempting to rewrite the Chilean constitution. So he really can report from the front lines of that. Then we'll turn to Jacqueline Dugard, a senior lecturer in human rights and political science at the Institute for the Study of Human Rights and the Political Science Department at Columbia University in New York City. And though she's now based in New York, Dr. Dugard taught and practiced for many years in South Africa and has written extensively on rights to land, property, and water. And then finally, we'll hear from Katie Boyle, who is professor of human rights law and social justice at University of Strathclyde in Glasgow. Like our other speakers, her work has had real-world impacts. Professor Boyle's research examines the legalization of ESC rights in different constitutional settings, and her research is being implemented as part of Scotland's initiative to incorporate international human rights into domestic law. So before I turn the floor over to Professor Lovera-Parmo, there are a couple of logistical notes, just to reiterate maybe some of this Amanda mentioned, that we will have time for questions after the end of the presentation. So please put questions in the Q&A. The chat is disabled, so put them in the Q&A. And then the presentation will be recorded, as I hope all are aware. For those who are seeking continuing legal education credit, the CLE code will be shared in the chat. Is that correct, Amanda? Yeah.
Yep, I'll put it in now.
Great, thank you. So each of our speakers will speak for about 15 minutes, so we have time for discussion, and I'll be loosely timing folks. And I'll then, with that, turn it over to Professor Lovera-Parmo. You can go ahead.
Well, thanks, Marta, Amanda, for putting this amazing panel together, and it's a pleasure to be with every one of you. Sharing, this is what I want to do, share some of my experience at the expert commission. So if you allowed me to briefly explain how the process was designed before moving into the presentation that I have for today. So we've embarked as a country in a process to rewrite the Constitution, the 1980 Constitution that was put in place by the dictatorship. And we had a first attempt during the last year that was rejected, massively rejected, actually. 62% of the people voted against the proposal. But political forces decided to put in place a second process. And this is the one we are ending during these days. Actually, there's going to be a plebiscite on December the 17th, where this new proposal is going to be again put for the people to decide whether they want to accept it or not. And this process was composed of two main bodies. So the first body, which was the one I was included in, was called the Expert Commission. So there were experts coming from different political positions that were nominated by Congress to prepare a first draft. And then that draft was later put in the hands of the Constitutional Council, which is a body of 50 elected people that were in charge of reviewing what we have done during the first part of the process. So what I want to show, this is my modest goal today. I want to show how there are some difficulties when we are discussing and deliberating about how to include social rights in a constitution. And to me, that big difficulty in the case of Chile, and I don't think that this also can be this can be universalized, but it was the difficulty we faced during the debates, was always having in mind or in front the menace of possible judicialization. And this is what I want to show. That was part of the struggles that we have when we were, as I said, writing the social rights provision. So before moving into that challenges, into those problems that I think we found during the debates, I want to shed some light about the Chilean experience on social rights. So very, very quickly, I want to show which was the model that was in place before the dictatorship. So this is the 1925 model of social rights that was put in place following what was, I would say, a political and an enabling constitution. So it was the 1925 constitution that was understood to be, rather than a legal, it was a political decision, and it was to be implemented by the political bodies, particularly by Congress. And it also was enabling in the sense that its quorums for amendment, its quorums to pass legislations were pretty low. So despite the fact that the 1925 Constitution was also implemented, I wouldn't say in a democratic fashion, but rather with military mobilization and in a rather vertical way, it was actually imposed. this openness that the Constitution had allowed the Constitution to be democratized during the following years. Specifically dealing with social rights, what we can see in this Constitution was that there was a kind of national health system put in place, thanks to some of the provisions of the Constitution. There was also a public pension system, besides some workers and unions organizations that also perform the work of a public pension system, and both public and private schools, but with a massive preference for the role of the state in directing and controlling the way this, I would say, the educational model was, or the educational system was framed, regulated, and implemented. Of course, then came the coup d'etat, and then we have a totally different model under the auspices of the 1980 Constitution. Different from the 1925 Constitution. The 1980 Constitution was more of a legal, juridical document, and it's also called as a cheating constitution because it had many locks and traps that were meant to chill the dictatorship model of politics and social rights. So what we see in the 1980 Constitution as the model of social rights, if we can call it a model of social rights, I still remember the first time I met Jackie Dugard was back in Norway in 2008, and when I said that I was coming from Chile, we were there meeting for a right to water conference. Jackie said the model of the anti-model. So let me use the word model very broadly here. The 1980 Constitution included private health insurance as a parallel system to the public system in the provision of health. It also included a private pension system that is the one currently in place that forced the public system to a close. There's still some people that are still being the recipients of those publicly funded pensions, but it's a very small amount of people. All of us who work, all of us who have an income, we are forced by law to be included in the private pension system. And of course, both private schools, just as under the 1925 Constitution, but today with a constitutional emphasis in the liberty. This is a constitutionally protected liberty to create and manage schools. So this has given place to a two-tier system for the provision of social rights in the areas of health, pensions, and education. Let me show how this parallel system works by taking a quick look to the right to health. In the case of the right to health, how it works. So besides regular taxes, each month, every citizen must contribute with 7% of his or her income to the health care system. So that's besides regular taxes, we call that a cotización, like sort of a prime to fund the health care system. But this is the trick. We can decide whether to enroll in the private or the public system by taking that 7% to the private or to the public health system. And to do that, we have a constitutionally protected right to choose. So this is the right to choose whether we want to enroll in the private or in the public system. Of course, some people can afford to pay the private insurance companies' plans, and those who can do that, of course, they can enroll in the private health care system. All the rest of the people who cannot afford to pay with their 7%, the prices of the plans that are offered by these private health providers fall into the public system. So this is the two-tier model of provision of social rights. Those who can pay can actually exercise the right to choose, and they can move to the private system. Those who cannot pay those plans fall into the public system. And this creates, of course, large inequalities. If you take a look at this quick chart, you'll see that today we have 17% of the Chileans enrolled in the private healthcare system, whereas something about 82% of Chileans are enrolled or fall into the public system. But when you take a look at the contribution that those citizens enrolled in those different systems contribute with to those different systems, you will see that those enrolled in the private system contribute with $4.2 million per year compared to those $2.3 million that those enrolled in the public system contribute to the public system. So this, as I said, create large inequalities. Private providers, of course, perform better than the public providers. There are no queues. Times for getting a prescription or to get a doctor hour are, of course, much more quicker than in the public system, and that is because it's better founded, and of course it has far more or less people affiliated or enrolled in the private system. So of course this was part, and I would say was the main claim that was behind those large protests that we had back in 2019 during the social upheaval. There were many claims, many challenges to the authorities, but I would say that one common line of argument against authorities was the need to have a new model for the provision of social rights. As I said, the Constitutional Convention during the last year proposed a change in that model. It was more inclined to the state. That proposal was rejected. And now we are facing a new proposal that I was lucky to participate during the first stages of this process. So this is the challenges that I want to put on the table to discuss. There were, of course, I would say, ideological barriers to include social rights in this proposal. And this is because, whereas in the expert committee, we were two big blocks of political representatives that were in some sense tied, so no one had the majority to decide by itself. In the case of the Constitutional Council, members were mostly from the right-wing parties and far right-wing parties. So they strongly oppose to the inclusion of social rights. They strongly, of course, oppose to any I would say preference for the role of the state. And as I will explain later, this is the reason why we have today some strange and weird social rights provision. But also there were disciplinary barriers, and this is what I want to call the attention to, because every time we're discussing a social rights provision, every time we're deliberating and debating a social rights provision, the main problem that we face, besides those ideological barriers, were, I would say, the menace of judicialization. So we were always trying to see how will courts interpret these clauses, and that, in the end, meant that it was almost impossible to give place to a robust set of social rights. So we have some social rights included in the proposal that is going to be put to plebiscite in December, but those provisions are surrounded by different barriers, because we were always facing this menace of judicialization, especially from the right-wing parties and far right-wing parties. They strongly oppose the judicialization of social rights, and this was always a barrier that we faced when it came the time to discuss social rights. I'm not saying, and actually in my academic work, I'm more inclined to prefer the political implementation of social rights rather than a judicial approach to their implementation. But and of course, I'm not saying that courts cannot perform any role when it comes to social rights, but this was, as a descriptive matter, what we faced during the work of the committee and the council when we were, as I said, discussing and deliberating social rights. And this explains why we have some different provisions today in the proposal. On the one hand, we can see that we have included these guiding principles for the realization of social rights. And I would say those are the usual suspects that you always see. As you see, the state shall take appropriate measures to realize the rights to health, housing, water and sanitation, social security and education, taking into account the progressive development to achieve the realization of these rights, the assurance to an adequate level of protection, non-discrimination, removal of obstacles, and the use of maximum of available resources. As I said, these are the usual suspects. But on the other hand, we also have strong restrictions on the role of courts or judicial intervention. So take a look at these two clauses, and I will finish with this. Article 25 includes this weird, as I said, provision, conforming to which, in the application of an interpretation of these provisions, courts cannot design, define, or step into the definition of public policies, because they understood that the definition of public policies is for Congress or for the administration, but not for courts. And then also when it comes the time to implement the emergency constitutional action, a kind of an injunction where you can actually, this is what in Latin America we call amparo, is also limited only to those benefits that are expressly established in law, which may, as I believe, run the risk of leaving besides all the administrative regulations that also are critical for the implementation of social rights. In terms of the proposal, I believe this is a proposal that is not good for social rights. It has some nice words that refer, as I said, to the usual suspects, but in the end is a proposal that will end up radicalizing the 1980 model of provision of social rights, and this may, I believe, just replicating the same problems that we are facing today. I'm on time, Marta. Thanks.
Yeah, thank you. Thanks very much, Domingo. So interesting that the advances on justiciability that I mentioned earlier actually then have this sort of boomerang effect of making it that much harder to actually implement or actually include economic social rights in the Constitution. So let me turn then to Jackie Dugard for her remarks. Thank you, Jackie.
Thanks very much, Martha, and thank you, Domingo. I have been really wondering what has happened in the second attempt, and so discouraging to hear that the social rights haven't gained much ground there, but not surprising given the parameters you spoke about. So I'm going to talk about a slightly earlier process, which is the South African process, which obviously was sparked by the negotiated transition heading up to our first democratic elections in 1994. And just to very briefly state what I think most people understand as the context in South Africa being coming out of colonial apartheid, which was a comprehensive system of discrimination, supremacy, exclusion, marginalization, and oppression, obviously a racialized system of such. But I think what is very important to note is that alongside classic civil and political rights, oppression and marginalization and exclusion, it also was very much premised on a socioeconomic exclusion and marginalization, which involved all spheres of economic life, including where you could live, what jobs you could have, but also, very importantly, dispossession of land, widespread disposition of land, first by the colonial regime and then the apartheid regime, such that 80% of South Africans, that is the Black population, were almost completely dispossessed of their land, which then was taken over forcibly by the white minority. So unsurprisingly, at the negotiating table for the new constitution, the issue of land was the number one issue and hotly contested, obviously. So I will circle back to the issue of land, and I just to state up front that I regard land and property as being a socioeconomic rights issue, although sometimes there is some sort of separation between socioeconomic rights and property or land, but I'll move through that and talk about it. Just to share some slides, first of all. Okay, so first of all, I think it's maybe useful to start with how the South African Constitution, the 1996 Constitution, which, by the way, we call the final Constitution. There was an interim Constitution during the negotiations period. We call it the final Constitution, but of course, nothing is historically ever final, and we're very aware of that. But it has been regarded and described by Etienne Mureynik as a bridge from authoritarianism to a new culture of justification, a culture in which every exercise of power is expected to be justified. And that means not only political power, but also socioeconomic power. And then Karl Clare, most famously in a 1998 article on legal culture and transformative constitutionalism, described our constitution as a transformative constitutionalism. And he described transformative constitutionalism as the long-term project of constitutional enactment, interpretation, and enforcement, and the commitment to transforming social, political, and economic institutions and power relationships in a democratic, participatory, and egalitarian direction. So what did Karl identify then as features of a transformative constitution, as opposed to a liberal constitution, such as, for example, the US Constitution? Karl defined these three different important features of a transformative constitution. The first is that there has to be some historical self-consciousness. And we see this in our preamble, where we say that we recognize the injustices of the past, and we seek to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental rights, and improve the quality of life of all citizens and free the potential of each person. Then Karl's second point about what a transformative constitution would look like speaks about that it must intervene in the private sphere, because of course you have a lot of private power when you're dealing with, for example, a racialized system of exclusion like in South Africa. So in the South African Constitution, you see in Section 8 that the Constitution applies to all organs of the state, and it can apply horizontally. And you see that increasingly now in South Africa, we are applying the Bill of Rights and its obligations horizontally, including sometimes the positive obligations. And this brings us to the third and most relevant for this conversation that Karl Clare identified about a transformative constitution, that it must have a clear egalitarian direction, and it must include positive socioeconomic rights obligations. So we see this both in what we call our equality or non-discrimination clause, which is Section 9. It is an expansive, non-exhaustive list of grounds on which there's a prohibition on unfair discrimination. It explicitly allows affirmative action. In other words, it prohibits unfair discrimination, but it's not considered to be unfair if you are advancing a measure to overcome historical disadvantage. And it very explicitly has horizontal application in that private citizens may also not unfairly discriminate, whether directly or indirectly. And then finally, on socioeconomic rights, we explicitly have socioeconomic rights alongside civil and political rights, with no clear distinction between the two. So they are explicitly justiciable under the reasonableness standard. And this is sections 26 to 28 of the Constitution. I would just also briefly mention that we have expansive rights to the environment in Section 24, which sometimes is regarded as separate to socioeconomic rights and sometimes included. And then we have extensive land rights in Section 25 of the Constitution, which I'll just move on to quickly now, because this was, as I mentioned previously, the most contested terrain in terms of the drafting of the Constitution. Importantly, for a country in which 80% of people had no land, and that those people were predominantly Black people, whereas white people constituting 6% of the population had 80% of the land. There isn't an actual right, positive right, to property or land. But there is, and this was one of the compromises of the negotiated settlement, there is a protection against arbitrary deprivation of property, which one can see as being certainly somewhat of a compromise in terms of the haves, and that was largely in 1994, of course, white people. I would say that the courts have interpreted this pretty progressively, and if we have time in the discussions to get on to how the courts have interpreted these various clauses, we can do so. But over and above this protection against arbitrary deprivation, it's very important to note, even though Section 25 we call the property clause, it actually, I think, is more appropriately and accurately the land clause. And the vast majority of the clauses here actually deal with land reform and redistribution and restitution of land in favor of historically marginalized groups. So you see in Section 25, subsections 2 and 3, it explicitly authorizes expropriation of property for a public purpose or the public interest, which explicitly includes land and natural resource, in other words, minerals, for example, reform. And very importantly, and I'm sure that this is something that Domingo, I'd love to hear how they're dealing with this in the current constitutional text in Chile, the question of compensation for expropriation of land in South Africa. It does not have to be market value. Market value is only one of the criteria. We look at the use. We look importantly at the acquisition, the history of the acquisition of the land. We look at any subsidies that the white farmers would have got over the years, and we look at the purpose of the expropriation. So we could have zero value expropriation of land. Then Section 25(5) is the right to gain, it establishes a right to gain access to land on an equitable basis. This is effectively creating a positive right for historically dispossessed people or historically marginalized people to gain land on an equitable basis. There is also a protection to the security of land tenure in Section 25(6). And then Section 25(7) is a specific right related to land restitution for people who were historically dispossessed due to racially discriminatory laws or practices. And then we have the extraordinarily powerful Section 25(8), which is what I'll end on, which is something that curiously has never been used by the government, and we can perhaps get onto that, but it exists with extraordinary power, I think, transformative power, that no provision of this section may impede the state from taking legislative or other measures to achieve land, water, and related reform in order to redress the results of past racial discrimination, provided that any departure is in accordance with the provisions of Section 36, which is our limitations clause, which effectively just is the normal kind of limitations clause about what is reasonable in a democratic society. And most experts, myself included, would say that this gives a wide scope to the government to pursue land and other reforms. So I think I'll end there just with the final note saying that what I think the South African story has told up until now is that having a constitution like this is necessary but not sufficient to undo historical injustices, that having socioeconomic rights and having land rights, strong land rights, is absolutely essential, but that you then thereafter need, obviously, courts that will interpret these provisions progressively. I think we've been lucky in South Africa in that the courts have, for the most part, done so, although I've been amongst those criticizing the courts for not going far enough. But the real failure in South Africa has been the government. And unfortunately, by now, all of the socioeconomic rights and land cases are opposed by the government, even though that they are essentially transformative and progressive cases brought by applicants, but the government opposes them. So you see now a really increasingly serious problem of lack of implementation of transformative policies and practices by the government. So yeah, maybe we can circle back to that during the questions. Thank you.
Great, thank you, Thank you so much, Jackie. And it's, excuse me, nice to hear my colleague, Carl Clare, his work being used in this kind of framing way. So I appreciate that. Now, Jackie has left out on the table and sort of offered a lot of suggestions for questions. So people that are listening, we've got more than 100 folks on. Please put your questions in the Q&A. This is the time to do it. And we'll be then circling back after we hear from our next speaker, Katie Boyle. So I'll turn it over to you, Katie. Thank you.
Thank you so much. I'm not using slides, so please do feel free to keep your camera on or off. I don't mind it, but otherwise, I just wanted to say a few points where I might draw upon both Jackie and Domingo's talks as well, because there's just so much rich evidence and comparative lessons to be learned, and also undertaking these journeys at the subnational or national level, where we encounter many of the same barriers. And in Scotland, which I'll speak about in a moment, the processes that we've learned from internationally have been invaluable in terms of comparative lessons and experiences, and particularly that commitment to transformative justice and transformative constitutionalism and social constitutionalism, and also in relation to Domingo's point about the importance of being able to address so many of the myths associated with constitutionalization of economic, social and cultural rights, and the importance of being prepared to address those myths and I suppose critiques of constitutionalization, including the threat of the judicialization of policy spaces and the various critiques associated with that. And so in Scotland, we're in a place right now, Scotland's it's subnational devolved state within the broader state of the UK. So we're operating at subnational devolved level, which adds its own complexities. But the UK as a state signed up to international treaties, including, of course, the International Covenant on Economic, Social and Cultural Rights. But we have no written constitution in the UK, and there's no domestic, it's a dual estate, there's no domestic legal framework for enforcing that treaty. So we have a huge economic, social and cultural rights gap, and what's happening in Scotland is there's an attempt to try and address that gap at the subnational level. So I'm going to speak about what's happening in Scotland, how we got here and what the future looks like. And I'm also just going to mention how wonderful it is to be on the call with Jackie and Domingo in terms of the contributions, because only in terms of solidarity in this space, about a mile from where I am right now, in the 70s, factory workers refused to work on jet engines of planes from Chile, jet fighter planes, as an act of solidarity. It was called the Nae Passeran movement. And that was in the 70s. And in the 80s in Glasgow, again, probably about 3 miles from where I am just now, Glasgow changed the name of one of its streets to Nelson Mandela Place in 1986, where the South African embassy was situated, as an act of solidarity with Nelson Mandela. So it's really beautiful for me to be on this call with colleagues. And because of where Scotland is right at this moment, we need those acts of solidarity really internationally and globally, because we are on the precipice of significant constitutional change, which is full of hope in terms of a socially progressive approach to social justice and embedding rights within our framework. But we are not there yet. So where we are right now is Scotland has just finished a consultation on a new human rights bill, which seeks to incorporate ICESCR as well as the UNCRPD and a number of international treaties. UNCRC is also included as part of a separate legislative framework. But the overarching picture looks like this: incorporation of economic, social and cultural rights, as well as the right to a healthy environment, to embed principles associated with international law, including progressive realisation and minimum core obligations, to have dignity as a sort of fundamental principle of interpretation in relation to those rights, and to do so in a way which seeks to embed not only the rights implementation mechanisms, but effective routes to justice when things go wrong. And as I mentioned, learning so much from the process of elsewhere. How did we get here? So Scotland is a devolved part of the UK, and devolution occurred in 1998, but Scotland's always had a separate legal system. Under the UK framework, it operates separately. So while acts of UK Parliament would apply to Scotland, it's always had a separate legal system. And many of the areas which are devolved fall in the space of economic, social and cultural rights. So health, housing, social security, partially devolved, education, energy, environment. So there's just so much potential there in terms of trying to close the accountability gap. And we had decades really of capacity building in terms of trying to get to a place that embraced a progressive human rights agenda. There is a UK-wide Human Rights Act which incorporates the European Convention of Human Rights, but as a regional treaty that doesn't extend to economic, social and cultural rights. So around 2005, the then 2015, the then First Minister Nicola Sturgeon announced a commitment to seek to constitutionalise, insofar as it would be possible within the devolved framework, economic, social and cultural rights. There were then two separate processes, which was the First Minister's Advisory Group on Human Rights Leadership and the National Task Force for Human Rights Leadership, where I was involved as a member, along with other academics and practitioners. But a really important aspect of that was the public participatory processes that go alongside it. And as part of those processes, one of the things that we sought to draw on in terms of comparative lessons, but also kind of deep understandings drawn from the literature and practice, where the importance of listening to lived experience voices, the importance of dispelling myths and the critiques of social rights adjudication. And along those lines, we looked specifically at the anti-democratic critique, we looked at the indeterminacy critique, we know that rights are too vague, we looked at the incapacity critique, that courts aren't equipped to deal with them, and we looked at the pro-hegemonic critique that constitutionalisation can actually lead to greater inequity in terms of distribution of resources. And we tried to address each of those critiques, and we used theory around deliberative democracy and building in things like, making sure the framework was accessible, that it was participatory, that we had sort of substantive fairness built in terms of both procedural and substantive fairness. And a really important aspect of that was embedding reasonableness review, which was more closely aligned to the likes of that type of review seen in South Africa, whereas our tests for reasonableness in the UK are very restrictive in terms of judicial review, be much more close to irrationality and manifestly without reasonable foundation, rather than a sort of the approach adopted in South Africa by the Committee on Economic, Social and Cultural Rights. And we looked at how to embed deliberation into the framework between institutions, both at the local level, between sort of different institutions of the state, but also learning from international experience, as well as making sure we included the local in that. We used counter-majoritarianism as a sort of response to the pro-hegemonic critique. So this idea of embedding rights in a way that where it created a space for those who would be marginalised from the system to have an institutional voice. And then we used sort of a remedial principle to respond to the concept of how important it is to embed justice in that framework. So some of the normative standards that we sought to, initially when we first looked at this, we thought, well, should it be an act of the Scottish Parliament, or how do you go about constitutionalising? We don't have a written constitution, we're not an independent state. So we looked at the ways countries do this all over the world, either implicitly or explicitly. And one of the things that we learned from that is you do need to find an appropriate model for your own particular circumstances, but it was all the other things that go with that to make it work in practice in terms of an everyday accountability mechanism and an everyday culture that's embedded across the framework. And this was some of the stuff that came really, really valuable in terms of getting public buy-in and including that sort of participatory element. So one of the key aspects of that was multi-institutional framework. And we looked beyond just the sort of typical, legislative, executive and judicial understanding of the state. And we're really keen to look at the fourth branch in terms of embedding accountability in this administrative sphere. So rather than just thinking that, the courts, obviously each branch holds the other to account, but we wanted to see how we could embed everyday accountability and local complaints mechanisms, the roles of inspectorates and regulators, ombudsman routes, tribunal routes, as well as court routes, and the court only ever being an institution of last resort. And in that multi-institutional framework, we also brought in, beyond the fourth branch, that regulatory sphere, we also thought civil society's voice needs to be heard, as well as genuinely public participatory processes that included lived experience as an epistemic community whose expertise was as valuable as anyone else. So multi-institutional accountability was an important part of that and helps respond to many of the critiques, because no one institution is responsible, but each has to embed accountability as part of their everyday frameworks. We were also keen to ensure, as I mentioned, the idea of proportionality and inflected reasonableness was in there, that we were looking at reasonableness beyond irrationality. And that was going to be a huge gap if we hadn't addressed it, because the courts here, one of the things we encountered was this idea, the UK framework is very reticent to socioeconomic adjudication, but when you look at it in practice, it happens every day. It just happens under the guise of something else, like equality law, or broad, interpretation of civil and political rights. So embedding that broader test of reasonableness creates a bigger space for evidence to be properly assessed and reviewed. So we're not just talking about transformative remedies, we're talking about transformative intensity of review, and that is a really important aspect which could easily have been overlooked had we not looked at that space more closely. We were also keen to embed dignity within the framework as an important gateway for people to get on board, as well as ensuring that we enabled collective access to justice. So a really key component of the research that was undertaken in Scotland and across the UK in relation to access to justice for social rights demonstrated that often the rights are, when they're violated, it's both systemic and clustered in nature. So clustered in terms of cross-cutting. When somebody experiences a housing issue, they're often also experiencing an issue in relation to potentially health, as well as employment, as well as education. So poor housing affects children's school, affects their health. You'd also see that sort of knock-on effect. So clustered issues, as well as the fact that when a violation occurs, it's normally systemic in nature. So it doesn't apply to just one person, but is a structural issue that requires a structural response. So again, that framework of transformative constitutionalism was really, really key to learn from example jurisprudence emanating from the Inter-American Court of Human Rights, from different states in South America that have embedded social rights in their frameworks, really importantly from South African jurisprudence, as well as from emerging jurisprudence in places like Kenya, and then those sort of adjudication journeys that have gone on longer and likes of India and so on. And then finally, in terms of that component, we realised that the system effectively does not operate for collective justice. It doesn't respond in a systemic and clustered way. We rely on individual cases. Class actions are not a big part of our litigation framework. But ultimately, and what the really important message was around that is that we don't want to create a system that is based on judicialisation and litigation. that needs to be there as a last resort. But what the attempt is and the goal is to embed everyday accountability across those multi-institutional frameworks. So everyone exercising state power, whether it be public or private, is applying the same normative standards. And finally, what does we look like in terms of the future? Well, the bill is due to be laid before the Parliament by May 2024, and would then go through, the normal passage of a bill. We'll know more about exactly what is in the bill in the next few months, but the recommendations of the bodies that have come before have very much worked on this evidence-led and participatory framing for constitutionalizing. One of the biggest challenges is that at the subnational level, there isn't autonomy over everything. So you have, for example, housing, which is a devolved area, but immigration is reserved, and large parts of social security are reserved, which means the Scottish Parliament would be acting out with its competence if it legislated in those fields. And the complexity of that has not quite dawned, I think, in relation to what incorporation will look like. That's not to say, though, that the ambition is not there. So one of the things that we'll need to pick and better understand is what that looks like, and that has there's political consequences in that sense. The Scottish Government and Parliament are behind the idea of embedding and constitutionalising the rights, and the UK Parliament and the UK Government is not there. So what we've seen is adjudication and challenges by the UK Government to any legislation that's come or has been forthcoming around this area. So Scotland has the power to observe and implement international obligations, but is restricted in many other ways. So we'll need to wait and see essentially how that plays out in practice. But at that, in terms of ambition and trajectory, it's progressive, and it does need that space in the global stage and critical friends to watch what's happening, particularly over the next months and years. So it's a really opportune moment to bring you the story in terms of where we are, and I'm very grateful for the opportunity to do so. I think you might be on mute, Martha.
So I'm just handing it over to you, Amanda. So go ahead.
Great. Well, thank you all so much. It was really great to get to hear your full presentations, and there's just, I think, too much, like too many questions that kind of came out of these detailed and exciting presentations. We do have 30 minutes, so we will take that time to have a conversation, and I hope that we can kind of dig into some of these, I think, bits that you left for us, suggesting that you could go further. I want to invite the attendees that are watching to submit questions. We do have a few here in the queue that we'll get to, and are glad to take more. I guess I wanted to ask one pretty general question to all of you first while we get the questions coming in. I'm curious, in your experience, how much do the definitions and the debates that are happening in the UN system, for example, in the Committee on Economic, Social, Cultural Rights, and the definitions that are in that space matter in the local and national context? Is it very relevant, the debates over maybe progressive realization or maximum available resources, or is it so translated and kind of separated from those debates? Is new meaning coming in the local space? If you could say any connection you see about that dialogue, I would say either legally or kind of in this accountability or political action space. And it's really a question to everyone. I don't know if we can run through the order again quick, and then we can turn to the specific questions. Domingo, do you mind taking that?
Sure, Amanda, thanks. Well, actually, in the case of Chile, what has happened is that it has been courts, the ones who have taken on the international human rights language. So you find sometimes references to treaties. You find sometimes references to general comments. You find sometimes references to the as I call them, usual suspects, the usual standards in the case of social rights. There has been a couple of decisions from the Supreme Court. We have both a Supreme Court and a Constitutional Court. We use the same parallel system. And the Supreme Court decided that despite the fact that the Constitution didn't mention any single time the right to water, that the right to water is included in the right to life, and it resorted to international human rights law to include the right to water into the right to life. So it has been courts, rather the avenue where international human rights law has been included. What we have today, sadly, as I mentioned, the vast majority of the council were members from the far right Republican Chilean Party, which is pretty close to the Republican American country, and it includes also some trends close to the alt-right and those kind of folks. So they are all against international human rights law. So they're very open to economic international law and very close when it comes to international human rights law. And we may talk about that later, but there's also one general provision in the proposal that mentions international human rights treaties, but commands courts to distinguish between binding treaties from those soft law provisions that are not mandatory for the state. This is part of the trend I think we are facing in different parts of the world, and sadly for us, it was the one who take the lead in the council. But yes, courts, Amanda, has been the avenue where those provisions have been included, and it's also very, very usual to hear those principles as well in the legislative arena. And as I said, we were able to include some of these principles in the proposal, although I think the other parts of the Constitution leave them without much effect.
Great, thanks, Domingo. Jackie?
Thanks. So in the South African context, I think you see an interesting dialectic. The time when we were drafting the 1996 Constitution, we did in 1994, we signed ISESCA, but we didn't actually ratify it until 2015, which I think must be a world record. And, you know, there are some weird reasons for that. But in the meantime, we did advance on the domestic front with a constitution that essentially covers pretty much everything, although the wording is slightly different. Our wording is that the state must take reasonable measures within available resources to progressively realize the right. And on that front, we had the courts in the early cases of TAC and Grootboom apparently reject the international minimum core content standard, but I say apparently because when you actually look at the judgments, certainly the ones outside of eviction cases, which have been the majority of socioeconomic rights cases in South Africa, but the few that have not related to evictions and the right to housing, you see that the courts do actually, in my argument, pursue a kind of a minimum core content approach anyway. And that's also because much of our legislation provides a minimum core content to these rights. But one interesting thing in the dialectic between international and domestic in South Africa is that South Africa's way of adjudicating socioeconomic rights in these early cases via the reasonableness standard of review was ultimately taken up by the Committee on Economic, Social and Cultural Rights in terms of the optional protocol for individual complaints. So you see this two-way engagement between the domestic and local in the South African context.
It does seem like the direction of influence is circular in that sense. We can see the influence of South African thinking and history and the norms. That's super helpful. Great, thanks. And Katie?
Yeah, very much so. I think recognising that there is no panacea for this. There's no country that's done it absolutely perfectly. The international framework's not perfect. Is an important place to recognise there's room for growth, but also it helps address like those critiques I spoke about, one of which is the indeterminacy critique. So one of the things we often encountered in discussions around this and pushback was that the international framework indeterminate and also sometimes contested, and perhaps lacks clarity in spaces, which is, you know, like any piece of legislation. But in Scotland, what's interesting is it's an invaluable, it's an indispensable source, because it's not there in the national framework, and it's a really important hook and democratic framework on which progress can be made. And it's also something where there is devolved power and competence to act, because Scotland has the power to observe and implement international obligations. So it's been indispensable to Scotland's journey. Having said that, another component of that, and another response to the indeterminacy critique and the spaces that are vague in there, and I think Jackie's point about the learning process going both ways is really important, because it helps recognise that dialectic process allows for learning and dialogue, and everything that we were doing demonstrated the importance of deliberation across institutions, and then at the nexus between international, national, domestic, devolved rather, and local. And so one of the things that we sought to do to help address the indeterminacy critique was to have more public participation in giving greater meaning and content to rights. So, for example, the way that the minimum core will be embedded into the Scottish framework, the proposal is to have a public participatory process to give meaning and content to what that ought to mean within the Scottish framework. It helps in terms of enabling buy-in, but also creating, well, you know, the international framework being the skeletal decision-making framework, where sometimes it's very clear what is meant, and in other places there's room for interpretation, and that interpretative process will include people who actually live in the conditions, who want to explain what it is to have a minimum core of dignity in the enjoyment of different rights. And so actually it brings it right down from the international to the person who is living through the experience itself.
Thank you. That's definitely, I think, what we're seeing too in work with some organizations in Ecuador, kind of the being able to support and legitimize some stances that they've had for a long time by trying to pull out even kind of interpretations from special rapporteurs or other kind of, like Domingo said, maybe soft law sources that are very helpful but are maybe quickly kind of rejected. We'll turn now to the list of questions that we have. We'll definitely welcome others. I'm going to try to put a couple together here, Jackie, that have come in for you, asking for some more discussion on the South African context. Kind of recognizing the dynamic of having really progressive rights codified and then maybe less support in the courts or powers. If you could say more about the option for private citizens to be bringing suits and any other strategies that you see advocates bringing to bear with that dynamic.
Okay, sorry, I should just answer that one question now. Yeah. We have one of the many features of the new constitution. The 1996 constitution was very broad rights of standing. So we have pretty much anybody can bring a case on socioeconomic rights. I know that's, well, I assume, Domingo, that it's the same in Chile. Like there have been some critiques, for example, in Brazil, that socioeconomic rights have been captured by the middle class. That is not the case in South Africa, because we don't really have an individual claim to a house, etc. It's a collective right to a reasonable government program. So you don't find middle class and above people bothering to litigate on these issues. It's really only something that's low-income people do in order to try to enforce essentially both what is the constitution, but also government programs and policies. So I see it as a very, very important political and accountability tool. I see socioeconomic rights as primarily that, and it's definitely not been captured by more affluent classes in South Africa. So yes, people, private citizens can bring these cases and do regularly, and the courts entertain them all the time. And by the way, in almost every single socioeconomic rights case that has ever been brought in South Africa before the Constitutional Court, the applicants, meaning low-income, poor people, have won.
Thank you, Jackie. And there's space in the Q&A if anyone wants follow up on that also. I'm going to raise a question that's come in asking about hyper-presidentialism. So I'm wondering if any of you could comment maybe on the executive branch in this look at economic, social, cultural rights, whether it's kind of the balance that's built into constitutions. The question is suggesting or asking the question whether hyper-presidentialism favors the effectiveness of these rights and thinking about that organic construction of constitutions. I'm wondering if any of the panelists want to comment on that dynamic.
If I can say something, Amanda, about that, because I believe the question has two parts. So the first part is asking whether we also have to pay attention not only to the substantive provisions of Constitution recognizing rights, but also to what we call normally in South America organic, but to what Roberto Gargarella has called the engine room. So how the power is exercised by Congress, President, and so on. And his critique, which I think is very sound, is that we sometimes pay too much attention to the substantive clauses, and we waste time trying to get the perfect social rights provision, and we forget how those provisions are to be implemented by political powers. And I believe that's a key question, because sometimes you have regulations to the exercise of power that may actually run counter to the implementation of social rights. So let me mention two examples in the case of Chile, but I think it's also the case in other parts. We have, during under the 1980 Constitution, what were called supermajority quorum laws. So there are certain legislation that needed for 7 parts of Congress to be passed. And that made that many decisions regarding, for instance, education were almost impossible to pass because of those burdensome quorums required by the Constitution. The same with transfers of economic power from the central state to local governments and regional governments. If you don't empower economically those local governments, then citizens from different regions of the world, and if you don't know, Chile is a pretty thin and long country. You have to travel, and you have to all the time being asking for the provision of social rights to the central state, and that make the realization of social rights very difficult. And I think that is all those regulations are in some way part of what has been called the negative constitution, the idea that constitutions only have to contain power instead of enabling the state to fulfill the citizens' demands. And this is what we tried to do during the beginning of the work of the expert commission. We coined the idea of that we need to have a constitution that is enabling of politics, that you need to empower the state, Congress, and the president so they can actually meet the people's demands. So I believe that that question is posed by Andres, I believe, critical. And whether the president and hyper-presidentialism can help realizing social rights, well, I think it depends. If the president have big or large presidential powers, as the one they usually have in South America, well, sometimes they can help in implementing more quickly than the legislative process some of the measures that may be realizing social rights. On the other hand, the problem is that those measures are either transitory or can be always rejected by a higher legislation. So it's something that you may have some winnings in terms of time, but it's not as stable as a legislation.
Jackie or Katie, did you want to add any reaction or points on that? One question that I'll pull up here is I think we do have a lot of people tuning in from the United States. And so, of course, I think, and we think our US law students always kind of have this block when we start learning about economic social culture rates because it feels so foreign. I'm just wondering, and building off the question here, and I wonder if the lens is either equality or the calls on different treaties and human rights thinkings for affirmative action as reparations or kind of redressing systemic discrimination and inequality from the past, just either for lessons for the US or in other contexts, kind of how can we look at constitutionalized economic social cultural rights or constitutional protections related to equality and addressing past discrimination? Are there avenues for advocates at that intersection?
Can I mention this fantastic case, which is a Canadian case called Toussaint. Now, Toussaint, it was brought under the Human Rights Committee, so under the ICCPR, because Canada hadn't ratified the optional protocol to ICESCA. And also Canada regards itself as a dualist country without self-executing international law. And this case is really, I commend everybody to have a look at how you can bring a socioeconomic rights case via the right to life. And I think this is something that Domingo also mentioned. This is something that many countries do themselves. India and many Latin American countries do this all the time. But here we have a growing jurisprudence under the Human Rights Committee at the UN level of interpreting the right to life very broadly. So certainly to encompass the right to health, but you know, in the general comment 36 by the Human Rights Committee, very, very even broader, talking about right to housing, et cetera, how one might be able to make a case under the ICCPR. So if your country, like the US, has ratified the ICCPR, of course, I understand that the US hasn't ratified the optional protocol, but still, all of these things begin to provide political mobilization platforms. And I think this is what the really important thing is about the law, how it can act as a mobilizing tool and an organizing tool and platform, even if you can't directly get at something.
Great. Katie or Domingo, do you want to add on that?
I might just add, and Jackie will know this case much better than me, but the Mahalunga case in South Africa, one of the things we were looking at was intersectional inequality and how to sort of embed substantive equality. And I just found that case a particularly inspirational one to read for many different reasons, but it does draw in sort of really excellent research done by the likes of Shreya Trey on intersectional discrimination, how to build those cases, recognising, you know, the legacy of apartheid, the legacy of colonialism. It involved Black women who were domestic cleaners who were excluded from, I think, a social security provision, and the court's approach to it was to accept intersectional discrimination and the consequences of structural inequality. And in a country that doesn't have that embedded in it, like the UK, that is a complete game changer in terms of how you look at it. But also what was really interesting about that particular case was how it framed people who are subject to intersectional discrimination, who are often referred to as vulnerable groups, but instead of looking at them as vulnerable as a personal characteristic, it reframed it as vulnerable because the system has marginalised them. So it's the system that has put them in the circumstances that make them vulnerable. But actually, to be a person who seeks justice in those circumstances, you are so far from vulnerable because you have to be a warrior to get to the stage where resilience is literally coming out of your pores in order to challenge a system that is marginalising you. And I found that also very inspirational. So Mahalunga is the case. I'll try and look it up and pass it on. Oh, thanks, Jackie. Thank you.
So Amanda, if I could just jump in with kind of an addition to the question you asked about US law, and just to say that just last Friday we got the concluding observations from the Human Rights Committee on the U.S. Review. And one of the things that was in there was a discussion of the right to life and a admonition to the U.S. around the human right to water as a part of the human right to life. And of course, the U.S. not ratified the Economic Social Rights Convention, but that right to life provision allowed the committee to talk about Flint, Michigan, the other areas in the United States where water has really been a significant issue. The other aspect of that is, and this kind of relates to, in a way, what Katie's been talking about in terms of subnational distinctions with subnational frameworks from national. In the US, of course, there are 50 state constitutions. 34 of them provide an inalienable right to life. It's a provision that is different from anything that's in the federal constitution. And so there is a great opportunity under those state constitutions to develop that jurisprudence. It's happening now, actually, in the abortion area to some extent. But of course, that right to life can encompass a range of things. And something that the international sphere is something the state constitutions, state courts can look at in interpreting these provisions that are unique to state constitutions. I wanted to ask, thinking about the subnational and national distinctions, and Domingo, you kind of alluded to this, with the effort in Chile to enact a new constitution that hasn't been successful. Is there any pressure at the local level to do something along the lines of what Scotland has done in thinking about how to adopt subnationally, economic social rights in a robust way? So let me put that on the table.
Yes, Marta, absolutely. Actually, the convention, which was the previous body whose proposal was rejected, moved from what we have today, which is a unitary state, to a regional state, which is closer to the Spanish organization. So it's not a federal state, but something in between. And it made lots of political as well as economic transfers of power to the regions, which is how we call the provinces. Sadly, the proposal was rejected, and one of the backlash that that rejection brought was that during this process we decided, and I said we decided because I was also part of the negotiations that led to this new process. We decided to include some borders, mainly relying on the kind of South African experience. So we had some borders that were not at the disposition of the bodies of this process, and one of those borders was the idea that we have to preserve a unitary state. So sadly, as I see it, the proposal today maintains the idea of a centralized state with some provisions allowing the transfer of power to local governments, but not on economic matters. We are a very structured and order in economic terms country, and some people were very, very reluctant to allow local governments to generate national endowment and debt. So that was something that was very, very critical to move to a different model of organization, sadly.
We're coming close to our last 5 minutes. I'm wondering if somebody would like to comment on Cooper's question here, asking about how constitutional approaches to economic, social, cultural rights might be impacting businesses, and he's especially interested in kind of corporations that are operating transnationally and responding to a lot of different legal frameworks. So if anybody on the panel has a reflection on that.
I think you, Amanda, and Marta should answer this question, but can I say something like very, very briefly on this, and this touch upon something that Jackie mentioned before. The amparo we have here, this emergency constitutional injunction, we have individual standing. So any individual person can actually ask a court of appeal to protect her or his constitutional rights. So the funny thing, and the critical thing as well, is that most of the social rights jurisprudence we have today has been produced by courts deciding on the access to the private healthcare system. So as it's a private healthcare system, it works under the rules of the market. So there are some public rules, but most of these private providers work under the market rules. So if you are women, of course, you have less chances to be accepted by this private insurance. And if you are older, less chances to be accepted. So what courts started to do under these individual claims filed by individual persons was to decide that these exclusions were contrary to the Constitution, contrary to the equality principle, and so on and so forth, and also that were running against the access to social rights. So it's funny how social rights standards in some way constrain what is a private business to accept those individuals that otherwise those private providers wouldn't accept. So in a sense, it has created attention, but in the same time, it has also provoked this backlash of putting courts away from designing public policies, as at least members from the right wing see that this was what courts were doing.
Katie, go ahead.
I'll briefly echo Jackie's comment that really, like, short of an international framework that properly regulates, it's very difficult to do anything extraterritorially in terms of regulating transnational companies. But the expectation is that states domestically do so through a regulatory framework, that kind of triangular relationship. So in the UK, actually under the Human Rights Act, Section 6 has a horizontal application. So any private company that is performing a public function, broadly defined. So for example, if you see privatisation of any public service, would be caught by the same duties and obligations that would apply to a public body. So not allowing the state to delegate responsibility, but ensuring that both the state and the private actor, the non-state actor, is responsible. And Scotland's mirroring that. There's two separate pieces of legislation, the UNCRC incorporation model and then the Human Rights Bill that has the broader incorporation approach. And both of them are trying to capture that horizontal application, and private non-state actors performing public functions are under an obligation to comply, including with minimum core, and should there be operating in a delegated space around progressive realisation also in relation to that as well.
Can I just say something quickly there? I think there's also scope for, while we wait for, hopefully, fingers crossed, a binding treaty on business and human rights, that there is a whole realm of shareholder activism, which is a possibility. And you see that now really rising in climate change litigation. So I think that's an interesting and hopeful avenue for trying to halt the excesses of transnational corporations.
I will keep my lips sealed for now since we're at the end of time, but maybe fruit for a separate conversation in our next webinar. In the few seconds that we have remaining, I'm wondering, I just want to give everyone a chance for the folks that are on the call. Many, we still have a huge audience with us. Is there somewhere you want to send people if they want more information, any resources or recommendations or kind of things you didn't get to mention in your comments that you want to kind of add in a last round? I'll just run through quick if you have something, or you could put it in the chat. Domingo, is there anything you want to leave us with?
Nothing at the time. Sadly, I was all this year trying to write down constitutional provisions, and I'm kind of exhausted. So I didn't have much time to do something else than be part of this process, which has been fascinating, but at the same time pretty frustrating for the results that we are seeing. So next time, maybe, Amanda.
No problem. Jackie, Katie?
I would just like to say that I am not afraid of judicialization of socioeconomic rights. I have found from the South African experience that the courts have been the champions of excluded and marginalized people, and that I think this is the way to go, actually, to try to do that sort of checking of power thing that the South African Constitution is all about. And I mean, I think there's never any substitute for political mobilization, but I see litigation and socioeconomic rights activism as 100% a part of political mobilization.
Katie, did you want to add?
Thank you. I would say to anyone interested, please keep an eye on progress in Scotland. Obviously, happy to signpost in any particular direction if anyone has queries by email or otherwise. But to keep, watch this space, Scottish Parliament over the next while. As I say, the consultation's just finished, and the bill should probably be before Parliament by spring.
Martha, did you want to add anything in our last minute?
No, I'm fine. Thank you, Amanda.
Well, great. Well, I will just say thank you. Sincere thanks to Katie, Jackie, Domingo, Martha, and Chitra. Great working with you, and appreciation also to Denise, who was really kind of helpful in shaping the conversation and whose work is really valuable in this space. I know in December there's a next installation of the Hernan Santa Cruz series, so stay tuned and watch the channels for that. And thank you, everybody, for joining us, and we'll see you next time. Thanks.
Thank you so much.
Thank you.
Thank
Okay.
you.